Hello, my name is Joseph Jordan. I'm a court-martial defense attorney specializing in the criminal defense of service members in the 5 services. And I want to talk to you a little bit about the Article 32 process. Now, the Article 32 is a hearing that only occurs in general court-martials, which is the highest court-martial. There's 3 levels of court-martials. The lowest level is a summary court-martial, the next level is a special court-martial, and the last level is the GCM, or the general court-martial. Now, what are the differences? I'll speak to them very briefly. At a summary court-martial, you're looking at a maximum of 30 days in jail, some rank reduction, and maybe some money taken away from you. At a special court-martial, you're looking at a maximum of a bad conduct discharge and a year in confinement. Typically, it's referred to as a misdemeanor court, but that does depend on the jurisdiction which you go home to once everything's said and done if you get the worst result. The last level is what's typically referred to as the felony court level. It's the general court-martial level. And they're all treated seriously, but this one is treated with the most seriousness. In the middle of this process, you have what's called the Article 32 hearing. Now, the Article 32 hearing is a hearing that is the civilian's equivalent of a grand jury. And basically what they do is they test the evidence and they make a recommendation. Now, with the new changes that Congress has come down with, it is required that a judge advocate be the investigating officer for Article 32s. Before, it wasn't a requirement. Now, in my practice, I have noticed that the Navy has already adhered to this prior to the new congressional ruling, and so did the Air Force. They always had judge advocates doing it. It was the Army that did not have judge advocates as Article 32 officers. And now that Congress is requiring it, they have to execute. So what is the Article 32 in basic layman terms? Well, you're going to have a hearing and the government's going to lay out their case. So whatever the alleged crime is, and say it's sexual assault, the complaining witness would typically testify, but with new changes, she doesn't have to testify. So what they'll do is they'll probably put in some documents with regards to whatever the investigation was. They'll bring in the investigators, they'll testify, and then it'll be the defense's opportunity to either put on a case or to test the evidence through cross-examination or direct examination, whatever tactics you choose to use. Unfortunately, with the Article 32 process in the military, many people will refer to it as a rubber stamp. That's not always the case, and that's not necessarily my experience. With sexual assault in the military, it's difficult to kick one. It's difficult to keep it from going to court-martial, especially if it goes to the Article 32. I've had the good fortune of being able to secure that result for my clients. I've been able to keep several Article 120 cases from actually going forward to the court-martial due to good advocacy and good investigation at the Article 32 hearing. Poking holes through the government's case enough to where they can't, it's just not a good idea to bring it forth to trial because they're going to lose on that charge. So it's important to have that experience. It's important to have someone that's willing to work and grind for you to get that result. So that's a little bit about the Article 32 hearing. If you have any more questions, if you're facing charges, pick up the phone or shoot us an email and we'll answer your questions. Thank you.